Okay, folks, make sure you have all those devices. Please make sure they turned off, put away.
Well, they changed the year after is
Come to order. Court is again in session.
Three people think that I am oversensitive in some respects. They think that the fact that my deputies here in court are constantly monitoring what goes on in this courtroom. Holding a photo. It was taken off someone named Aaron Murphy's, I guess, Twitter account. It's a photo of jurors. If I find out who this person is, you are going to jail. If anybody takes another photo of any juror in this case, you are going to jail. Mr. Schwartz, you may.
Thank you, Aaron. Let's hope our jobs can just get a little bit harder. Let's try to stay focused while we're here. We went through a lengthy voir dire. You fill out applications or questionnaires. This is a court of law. You've taken on a responsibility and you swore an oath, and we appreciate that fact. We do. And people have been attentive through the whole trial. But let's just remember why we're here. Regardless of who's in the audience, regardless of the media, that doesn't matter. What happens in this courtroom is what matters. The future of those two men is what matters. And the law and evidence is what matters. And that's it. We're going to begin and go out through this entire closing argument, and I will give the same apologies. I don't think anybody in this world deserves 3 lawyers for a couple of days. But it needs to be done. And I agree with Mr. Barnett, Mr. Rakakis, Mr. Tanizaki, Mr. Bogaris are good lawyers. And they're so good, they put on a week and a half worth of evidence and spent about 10 minutes talking about it. The rest that was spoken about, besides slicing in a little bit here and there, some law, was emotion. This case isn't about emotion. That's why we have courtrooms. That's why we have jurors. This case is about analyzing the facts, the evidence, and deciding based on those facts if they've met their burden with the law. And that's it. That's what the case is about. That's the only thing the case should be about. That's it. And maybe very hard in a case like this. I came to you in the beginning of this case, an opening statement, I talked about this was a tragedy, and it was. Any loss of life is a tragedy. We're not here to decide that. We can agree on that. We're here to decide whether or not that loss of life was due to a crime. That's it. And to get to that point, they have to prove it beyond a reasonable doubt. That's their burden. And they didn't do that. What they did is they put on a few myths in this case to play on those emotions and ignored the rest of the evidence. It's almost as if we weren't here for 3 weeks. But we were. All of us spent that time. You especially. The first myth we're going to talk about is the myth that Kelly Thomas, throughout this ordeal, was afraid for his life, that he started out being afraid for his life, that he was continually afraid for his life. That's a myth. He didn't want to be arrested, no. He found himself in the middle of a fight that he started, but afraid for his life. Now, Mr. Barnett went over quite lengthy that initial conditional threat that the prosecution claims would put a reasonable person afraid for his life. Quite lengthy. And effectively. Because you look at the words and you look at what was said in that first exchange that the prosecution claims led to everything else. You know, see these fists, they're going to F you up? The response was sarcastically, start punching, dude. That's not somebody who's afraid. That's somebody who's in reasonable fear. I'm about to get beat up. I might lose my life. That's somebody who doesn't care. That's somebody who's challenging back. That's the first myth. The reason the prosecution puts that myth in front of you and goes over it over and over again for 4 hours the other day, because they don't have the evidence to back up their case. They don't. They know they can't prove this case based on the evidence beyond a reasonable doubt. They know they can't meet their burden based on the cold, hard facts. All the details. Remember the details? Did you hear any details? You heard Mr. Rakakis stand up as a good attorney and say, well, this is what I think it means. This is what I think he was thinking, as if he was in his head. Did he give you the evidence that supports that? No. Not at all. So since they can't do that, let's play on emotions. Well, the first myth is the fear. The first example, the clear example, was the one that Mr. Barnett went over. There are other ones too. Here's another example. Understand, we have up on the Elmo, that's an excerpt from the prosecution's exhibit. Okay, that was their transcript of the overall event. There's other DARs. You've got Officer Munoz, Officer. This is from the overall exhibit, right? The overall one that they put into evidence. The entire altercation, the entire contact. This we're going to listen to in a moment. If you look up here, here's your watch. That's Kelly Thomas saying that. When does he say that? In the middle of the altercation, in the middle of the struggle, in the middle of it, before my client arrives. That's not somebody who's afraid. It's not somebody who's in fear for his life. Here's your watch. Listen to it. Could you play it, please? Yeah, Yeah, he's struggling, and when we struggle, we're out of breath sometimes, then we gain our breath, and we're out of breath, and we gain our breath. But here's your watch. He's not afraid. Who knows what he's thinking? It's not fear. Here's your watch. That's somebody who prosecution wants to paint as mentally unstable, maybe mentally ill. There's no evidence he really is. I mean, if anybody lives on the streets for 20 years, they're going to be a little bit off, no matter what, no matter who they are. Now, if the precursor to that was doing drugs, even more so. I mean, that's got to be a given. But that tells you that's a reasonable person in fear for something? Go back to the PowerPoint. That's a myth that the prosecution needs for you to agree with. They need that myth because they have nothing else. They need to play on that. Now, the people whose actions you're here to scrutinize are Corporal Cicinelli, Officer Ramos. And you scrutinize them by means of the law. A reasonable person in a similar situation, that means their knowledge, their experience, police officers. So what's this case about? What's it really about? What's this case always been about? The prosecution came to an opening statement. Remember? And the same type of approach. The first visual was put on that monitor was my client with his arm poised way up high like that. It was just one still photo, not the entire video, way up high. And what you were told is the evidence was going to show that was about to come down as a hammer strike. Emotion. Feel sorry. Feel bad. That's what he did. The problem is that wasn't what was about to happen at all. That wasn't the actual evidence. That was just the emotion of, look what's going to happen. Maybe I can get them upset up front. Maybe I can get them riled up front, and then they'll ignore the evidence. That's what he tried to do in the beginning of the case. That's what they've tried to do throughout the case. And we'll get into this much more. We'll get into the details. The devil's in the details, folks. You've been here to scrutinize details. We spoke at length in voir dire about whether you could be detail-oriented, because that's what a case is made of. Okay, we've been taught since we were children. Nothing is greater than the sum of its parts. Nothing. And if the parts aren't there, you don't have the sum of the parts. To have a building, you have to have a foundation. If they don't have the foundation, they can't pretend the building is there. Corporal Cicinelli raised his hand to hammer strike. That's what he claimed. Versus what really was on that tape, that he raised his hand because that was the end of an action of emotion of him wrenching, wrestling that taser away from the suspect. You know, we referred to the suspect as Mr. Thomas throughout because we know his identity at this point. My client didn't. He had no idea who he was. Let's go back to what you were shown in the beginning. It speaks volumes. You play it, please. That's what you were shown for opening statement. And if you look at that, point this over here. What was told to you was this arm up here, I think it was a little bit of a clearer photo, where it still was about to come down as a hammer strike on top of Kelly Thomas. Sounds really bad, looks very bad. Oh my. But let's see what that really was, that action. You play it, please. That's what that was. And look where his hand comes back down. Like this and off to the side. And how do we know that? We'll go over it in a few minutes. But you remember that entire line of cross-examination, Mr. Wilson? You remember how we looked and somebody was unfamiliar with tasers, but we went through it with him? Follow the light, because the light's at the end of the taser. So when you see that light on the ground, we see it reflecting, that tells you where the taser's pointing. So if you see the light, it's not hitting anybody in the head. Hitting anybody in the face. If you examine it, you can see what was going on. That's what that cross was about. And he had to admit that. He hadn't done that before. He wasn't familiar with that. They picked an expert from 3,000 miles away that had never been trained on a taser. Didn't even know what it was about. But once he started looking at it, really examining it, whatever 60-plus hours he spent finally having to examine it on cross-examination, that's when he realized. And we'll get to that point again, but again, that's the evidence in this case. Not emotion, not feel bad, feel this, evidence in the case. Go back to the PowerPoint. The actual evidence in this case, everybody agrees, even Mr. Markakis had to say in his closing argument, there were 2 strikes to the face. There were 2. And they were jabs. And they were short jabs. And that's how it was described by the prosecutor yesterday. That wasn't how it was described in the opening statement. It wasn't what they tried to get from Mr. Wilson. Do you remember that too? We went through this with him. We gave him his own opportunity to pick out the strikes he saw. Nobody said, is that a strike, yes or no? We'll stop the tape. You pick out the strikes. It doesn't get more fair than that. And he couldn't do it the first run-through. He couldn't do it the second run-through. And by the time he got to the third, he said, could we go slow motion? Now, if you remember, it was offered to him to go in slow motion. And with a bit of hubris, well, I don't look at things in slow motion. I want to be the officer's perspective. But he couldn't find it unless he went in slow motion. And in slow motion, he finally found 1 strike, only 1, that he could pick out, that nobody could lead him to. He picked out only 1. And the 1 strike, as we went through it, was to the outside of Kelly Thomas's left hand. And we'll go through the video a little bit in a little while. The outside. Now, we've had several doctors testify on more. I think we all know that the outside of somebody's left hand as it's reaching up isn't near the person's face at all. And the taser light was to the outside of his hand, so it wasn't near the person's face. And he had to admit that's the 1 strike he saw. And that strike was done because that same hand is reaching up trying to grab that taser and those wires. That's it. That's the actual evidence. Try as they might, the prosecution can't get away from it. They want to, they can't. This is a tough case, folks. It's a tough case because of the emotion, not because of the evidence. And how do we know that too? Think about how the case has been presented to you. The suspect grabbed my client's taser. Did you hear any questions of Mr. Wilson about would it be reasonable, would it be appropriate, would it be consistent with training for an officer to use that same weapon as an impact weapon if the suspect tried to grab it? No questions of him from the prosecution. But that's their burden. That was their expert. They flew him out. No questions. He was asked questions on cross-exam about weapon retention, how important that was. Now, if you remember, we went through that part with Mr. Wilson, and this is for demonstrative purposes. We'll get into more of the testimony. And he hadn't even realized. The first questions he was asked was about, you see him shifting to his left, that my client had to shift to his left if he was going to hit him in the face. That was a conscious decision. And he has to shift. Mr. Wilson, again, quick retort, well, no, we have peripheral vision. Were you aware my client doesn't have a left eye? It's a glass eye. He can't see through his left. He has no peripheral vision from this side. He's got no vision. Were you aware of that? Oh, yeah, I think I read in the materials. So that would make sense why he's shifting to his left, because that's how he can see the face. Does that make sense to you? Oh, yes, now it makes sense to me. Why did he do that? Because nothing else worked. Because he's been trained. They've all been trained. The ones who go out there and deal with a Kelly Thomas, a suspect, an unknown suspect who's been fighting with his partners for 2, 3, 4, 5 minutes, an unknown suspect who everything else in his training he's tried, which everybody agrees was reasonable, even the prosecution, hasn't worked. And now the suspect keeps grabbing at that weapon. And he's hit the hand, he keeps grabbing. The wires, he keeps grabbing. What's going to stop this guy and get a message across that he needs to stop trying to grab my weapon? He didn't drop it and take out his gun. He hit him in the face twice. And you know what? It worked. Kelly Thomas kept struggling. He kept fighting. He didn't reach back up for that weapon anymore. And that's what my client's been trained to do, is control the situation. Control a combative suspect. Keep him from grabbing his weapon. Something else the prosecution mentioned, and this is just yesterday. And this is the other part of how the case had been presented to you folks. Mr. Rakakis said, and I quote, "Now Officer Cicinelli comes, Corporal Cicinelli comes, and sees the situation, and of course, what's he going to think? This is somebody who's resisting a lawful arrest. That's got to be what he's thinking." That's the prosecution's position. That my client reasonably would be thinking that Kelly Thomas is a suspect resisting arrest, resisting two of his partners, fighting with them. So he takes a look at it, and he's going to get involved and try to help the situation out. That's admitted to by the prosecution. It was also admitted to yesterday that those uses of the taser, I mean, he said he tased him and tased him, but that's within the training. Nobody says that was wrong. That's what he's trained to do. Because if that taser works, game over. The suspect is incapacitated. We can get handcuffs on him. Nobody gets hurt. That's what they're trained to do. It may not sound nice, but that's a way of getting a person under control with no injuries. But it didn't work. And there's one more thing, one more piece of this that we want to listen to about the fear factor. Next clip. Okay. I want you to listen to how this is also in the middle of the struggle. And you've got the entire video in there. You've got all the DARs. This is on the main video for both the prosecution and defense.
Okay. I'm sorry.
Listen to how he says that. That's at the interim where they claim compression starts. That's at the interim they claim he's in fear for his life. Listen to how he says it. Okay. He's not saying like somebody's afraid. He's saying like somebody like, "I said, Uncle, now it's time to get up, please." "All right, fine. All right, you got me." That's not fear. And it's not somebody out of breath. Listen, can we hear it again?
Okay.
Back to the top one. That's the details. Those are the facts. I'll skip through this one. We just talked about this. That's what this case is about. It's not ignoring the facts, not ignoring the details, not ignoring what really happened that night. This case, from its start until now, by the prosecution, has been a mixed characterization of what happened that night, of the person they were dealing with, and what the evidence shows. Matter of fact, in the closing, Mr. Rakakis didn't say much what the evidence shows, except for his opinion. It's been misinformation. We'll get to that in a moment. And it's been misleading. We put our trust that you'll be fair and impartial. We put our trust that you do your best to analyze this with all the evidence. We'll talk about it in a few moments, but that's what you've sworn to do. That's what makes our system the best in the world. It may not be perfect, but it's better than everyone else's. That's a fact. Mr. Barnett mentioned that they had Corporal Rubio on the stand. They don't want to ask him the questions that we asked him, but they knew what he was going to say. He's the training officer. They didn't have only one interview with him. They had two. They had one a year earlier, as Mr. Burnett went over. They had a second one he testified just about a month before a trial. And in that second one, they spoke about my client and use of the taser as an impact weapon. And what a coincidence. He's not on the stand for them either about that. They don't like what he has to say. You don't just get to pick and choose if you have a burden of proof. You don't just get to cherry pick if you have a burden of proof. A burden of proof means I've got to live with the entire case, warts and all, and if it doesn't prove guilt, oh well. Not, let me just pick those few things out that can make an argument. Ignore everything bad for me. Hope that the jury can ignore it too, and maybe I can get one past them. That's not what a prosecutor should do. That's not what you can do. You can't. That's what they've done. Kevin Craig, they had in the stand too. He testified he wasn't just the sergeant on scene. He was that. He was a supervisor on scene. He was that. He also testified he was a field training officer. So he may not be the training officer on use of force, but he's a field training officer. He trains officers how to react and act in the field. They could have asked him questions about that. He testified to it. And he saw nothing wrong about what happened. And what's ironic is the people argued yesterday that he saw deadly force because he said that a weapon to the head could be deadly force, a taser to the head could be. And again, we're getting to the words because the way those questions were asked were very specific. Could, may, if, can, not was, not did. Could be. He didn't say what the circumstances were. Now, Corporal Rubio, who's the use of force trainer, he was quick to distinguish it. He said, it depends. Depends on what weapon we're talking about. Because an ASP, which has been compared to this taser throughout the whole case, and a baton, which has been compared to the taser throughout the whole case, are not like a taser. They're much heavier. They're much more solid. Those are what we call impact weapons. And that's what they're trained on. Now, the taser may be hard plastic. It may be some kind of material that doesn't like to break so easily. You can't compare it to a long, hard, wooden baton, like you just saw here, or a long, hard, metal asp. You can't. They've tried to because they've got nothing else. That's not right. But what Sergeant Craig said, he has never, and this was their questions, he was never on a scene where deadly force was used. He had never supervised a scene where deadly force was used. Now think about that. He was at this scene. He's testifying 2.5 years later. He's never been to a scene or supervised a scene where deadly force was used. He knows exactly what they're talking about. He includes this because it wasn't deadly force. Period. Now, I've got a friend of mine who had a very good analogy, and I didn't ask her if I could borrow it, but she's another attorney. I'm sure she wouldn't mind. We look at misleading. You know, there are different ways to react to danger, different ways to react when things are not going your way. And as an analogy in the animal kingdom, to pick out one specific that works for this case is an octopus. Octopus has no teeth that we know of. I mean, it eats its prey, but nothing that can attack someone. An octopus doesn't have any claws. When an octopus feels it's in danger, not even just being attacked, but in danger, in some form or another, what does an octopus do? It spews out black ink. So that its predator, or the danger, can't see anything. Everything becomes muddy, becomes murky. And the octopus can get away or be safe. In this case, that's what the prosecution has done. The danger to them is they don't have a case. They don't have the facts. They don't have the law on their side. They don't have that. So let's just muddy the waters. Let's just throw the emotions out there. Let's just throw our opinions out there. Let's forget. Don't confuse me with the facts. Don't do that. Black ink. It makes everything murky. It makes everything black. You can't see the truth. You can't see the details. You can't see what's really there. And they've been ignoring this entire trial what's really there, from start to finish. And I want you to think of two other things. This is the test that the prosecution put up as one of their exhibits. Now, you know, a sticker for the exhibit number behind it. And here you go. And somehow, again, the comparison being made that my client taking a test, a written test, back in 2000, 11 years before the event, about using an ASP. Somehow that's related in some form or another to his use of a taser as an improvised weapon on a suspect who would not stop trying to grab it. Somehow that means my client knew that the suspect, or rather the danger, didn't require deadly force. An ASP. They're not even close to being the same. But somehow we have to relate it because we have nothing else to relate it to. We have nothing else to compare it to. He did the same thing with Exhibit 33, which is a test he took in 2007, and he took another one in 2010. And I want you just to know the last question. I'm trying to work the Elmo. he got it right, but deadly force is justified under the following circumstances. B and C. To protect themselves and others from what they reasonably believe would be an immediate threat of death or serious injury. To effect an arrest to prevent the escape of a suspected felon. Now, Mr. Rakakis admitted opening of his closing argument, that my client reasonably would have believed this was a fleeing felon, resisting arrest. But it gets more than that. There are two parts to this equation that they keep ignoring. Here's part one. That was asked of the witnesses. Think about it. And this is just for arguments, folks, because it wasn't deadly force. And we'll go over how that is another myth. For argument's sake, if my client's 2 strikes to the face were deadly force, which means hitting somebody in the face with that taser could be deadly force. If that's true from the prosecution's argument, then if the suspect was able to get that weapon at that close point-blank range and hit my client in the face with it, wouldn't that be deadly force too? And the law says my client doesn't have to wait or retreat to actually get injured to stop that threat. And it is a threat because this person grabbed his taser at least once already. He was grabbing at the wires. Had been fighting with officers for 2, 3, 4, 5 minutes. Doesn't that make sense? What's good for the goose is good for the gander. They want to ignore that fact. They want to say, well, no, he doesn't get to do that. But he does. And that's what Corporal Rubio testified to. That's what Sergeant Craig testified to. That's what Mr. Wilson testified to. We're not going to allow officers to do that? We're going to say too bad? Let him hit you in the face, but you can't hit him? No. It's not just unfair. It's not how they're trained. It's not even the law. They ignore that. You can't ignore that. You don't need your common sense at the door when you walk in as a juror. But there's one more part to it. And this is the part they can't answer. And this is the part they have to answer. They have the burden of proof. They have no choice to answer this part. If you have a suspect who has been fighting with your 2 partners, struggling for 2, 3, 4 minutes already, and nothing you've tried has worked. Drive stun with a taser, darts with a taser, drive stun with a taser. Nothing's worked. And he's grabbing your weapon. And he's grabbing at your weapon. And he's grabbing at the wires. And nothing has worked. What alternative do you have that's reasonable? They've never given you one. They flew, a use of force expert reported, 3,000 miles. He didn't give you one. Mr. Rakakis stood up there for 4 hours yesterday. He didn't give you one. Maybe now a rebuttal will think of something at the end of the day, in the 25th hour. What other option would you have reasonable? And it's not just that. It's more than that. It's not just what option was reasonable, but based on the law, folks. Remember the law? This is an instruction you did get, and you have back there. We always have different names for instructions. We call this the circumstantial evidence instructions, sufficiency of the evidence. Not only does the prosecution, from their burden, have to give you another option he would have had, that option has to be so reasonable to exclude what he did. So if you have 2 options, and one's just more reasonable than the other one, he's not guilty. If you have 2 options and they're both equally reasonable, he's not guilty. Before you may rely on circumstantial evidence to conclude that a fact necessary to find the defendant guilty has been proved, you must be convinced that the people have proved each fact essential to that conclusion beyond a reasonable doubt. Each fact. It's not even just proving a principle. Each fact they rely on has to be proven beyond a reasonable doubt. Each and every fact. But it's more. Also, before you may rely on circumstantial evidence to find the defendant guilty, you must be convinced that the only reasonable conclusion supported by the circumstantial evidence is that the defendant's guilty. The only conclusion. Not, there's a few here, there's 1, 2, 3, but we like this one best. For them to win, the only conclusion. If you can draw 2 or more reasonable conclusions from the circumstantial evidence, and one of those reasonable conclusions points to innocence, and another to guilt, you must That's not a choice. That's the law. That's what you've sworn to do. You must accept the one that points to innocence. You don't have a choice in that. They've given you no other alternative. No other alternative. Not even one that's more reasonable, not even one that's the same. Not what they have to do, which is to the exclusion of what he did. None. And we'll get to how this applies, and it applies to the prosecution's case all throughout. However, when considering the circumstantial evidence, you must accept only reasonable conclusions and reject any that are unreasonable. We'll get to how that applies in a second. Now, we talked about the black ink. We're going to go over that a little bit more in our introduction. What's some of the evidence of the misleading nature of how they tried this case? The black ink that's spreading across this case. Let's go back. Remember Dr. Hugelin? He came under rebuttal. He's Singhania's boss. And let's be blunt. You've been here for a few weeks. You've been here for a number of days now in closing argument. He came in an attempt to clean up the train wreck that was her testimony. That's what he did. And what did he say? And look at the words. Look at the way they phrase their questions. Look at the way they phrase their answers. That's important in this case because there's a standard of proof here, beyond a reasonable doubt. There's a burden here. Dr. Hugelin, the record indicated that Dr. Lekawa noted significant amounts of blood in the airway that was related to nasal fracture. Now, the airway, he says. And the CAT scan that was done also confirmed the presence of blood aspiration as well. Look what he's trying to do. Make no mistake, he had an agenda, and so did the prosecution. According to Dr. Hugelin, Dr. Lekawa noted blood in the airway. Well, that means a blocked airway, folks. That means when he comes from St. Jude Hospital to UCI, he's been intubated by another hospital. He's got that ET tube sticking in him. They have a pulse now. According to Dr. Hugelin, Dr. Lekawa noted blood in the airway. Well, what does that mean for them? Why do they need him to say that? They need him to say that he had blood here and he couldn't breathe still. And that was evidence that way back when, at the scene, he still couldn't breathe. That was related to the nasal fracture. Now, that's what he claimed because he's still, at this point, trying to get you to believe that my client's strikes had some nexus to the cause of death, which it didn't. But here's what Dr. Lekawa actually said. What he actually said. When he came to us, he being Kelly Thomas, he had significant bleeding from his nose. We actually had to pack that in order to stop it. Now, this is what he says, and this is why it's important, because this is not meeting a burden of proof. And that bleeding can be aspirated. He didn't say it was into the lungs, which can block your airway. He didn't say it did, because it didn't. And it can also decrease how the lungs absorb oxygen. There's no evidence it did. We know this from his CAT scan, and he did have aspiration. So what they know from the CAT scan, and these are the people who are used to testifying, folks. They're public speakers, too. What he knows from the CAT scan is that there was some aspiration. But you heard even from Dr. Budoff, their witness, that there was no fluid in the lungs. On the chest x-ray, there was none. The actual evidence, folks, what was the actual evidence of this case? That the blood did not block the airway. That's the opposite of what Dr. Hugelin testified to. And that contradicts the inference that Dr. Lekawa was trying to create. Look at the evidence. See, we're going through the medical records, and we're all lay people. So things, we don't understand what certain terms mean, but we kind of understand some common sense. When Dr. Lekawa was being cross-examined, going through his medical records, he was asked specifically, what does this term mean? And look how he answers. One of the few times he said, because he got caught. No focal consolidation means that on the chest x-ray, they were not able to see, a pneumonia or a collection of fluid, or a collection of fluid within the lungs big enough to show up on a chest x-ray. He was caught. His inference was just an inference. It wasn't the fact, or it was not the facts of the case. He was caught. And again, common sense, folks. And Dr. Vilk, as far as the expert, bar none, in ventilation, still had common sense. It wasn't an academic discussion also. It was both. You know, you take your kid to the doctor because they have a hacking cough. What's the first thing the doctor does? They put the stethoscope there and they check the lungs to see if they sound clear. They don't give them a CAT scan. They check the lungs with a stethoscope to see if it's clear. If it doesn't sound clear, there may be fluid in there. That's the second thing they do. They don't give them a CAT scan. They send them for an X-ray. And if the X-ray shows up where there's some fluid, that means there must be something in there significant. Then we do the CAT scan. Then we worry about other things. I mean, even from an X-ray, if there's something in the lungs, they give the kid half the time some kind of medicine, right? If there's an infection, we don't have pneumonia, we don't have bronchitis. Take your antibiotics, go home. Because if it shows up on an X-ray, it's significant enough to mean something. But if it doesn't, it's not. And how do we know that too? What does Stanchik testify to? Remember, these are the myths. This is the black ink. Because what they tried to create didn't happen. And that's why Mr. Akaka spent all of 10 minutes on his medical experts that took up a week and a half, 10 minutes in closing. Because not only does it not prove his case, it disproves it. Now, paramedic Stanchik, he's a medical professional too. He's not a doctor, but he's been a paramedic for 20 years. And he had training in a hospital, in the field. And he said, at that point, once we were able to clear his airway, we found out that he was now a viable patient. Able to clear his airway. And he told you what that meant. That meant wiping his face, basically. Because he was breathing through the nose, there was air. And what he also told you is he didn't feel there was a need to intervene. He was breathing strong enough. They didn't put any oxygen on him. They didn't try to use an ET tube. They didn't even do the oropharyngeal and the ambu bag yet. He was breathing enough to sustain life. There was no need to intervene. And what Dr. Vilk said, who, by the way, was not only just the expert bar none on ventilation, he was head of EMS, Emergency Medical Services, in San Diego County, for the entire county for 4 years. Head of it. He had to scrutinize medical service from paramedics for 4 years. What he told you is, if you got 2 paramedics and 2 EMTs right over a patient, and he's not breathing enough to be alive, and they're not doing something, it's malpractice. It's ridiculous. So either they committed total malpractice there, or you have to believe what Stanchik said and what Zilgit is about to say, that he was breathing. And he's breathing enough to be alive, and they weren't worried about it even. They could wait because they were there for 6 or 7 minutes. Now, according to Dr. Lekawa, remember we had that questioning? We asked him, how long would it take for a person not breathing at all from being compressed? So no breathing before it would be irreversible hypoxia, irreversible anoxic brain injury. And his response was 1 minute, which again, think about it. Doesn't make sense, but that's what he said. You can hold your breath for a minute, right? But he said 1 minute. They were there for 6 or 7 minutes without intervening. If you go by Dr. Lekawa, he's been dead 6 times over. But he wasn't. Because there was nothing blocking his airway. Paramedic Zilgit, what did he say? Getting used to the clicker. He said, and this was a suction question, and this question caught Dr. Lekawa off guard too. And is there a procedure to remove any blood that might be in the throat or the airway that would prevent, if we saw blood inside the airway, we would suction? Okay. So you look and you see if there has been liquid blood in the airway or in the cavity. Correct. And then you suction it if it is. If it's there, right? Correct. And there was none there? Correct. The myths of this case. Well, the strikes to the face cause enough bleeding to block an airway, cause aspiration, affect the breathing. Not according to the evidence. I don't care how much they want to say it, not according to the evidence. That's what you've sworn to look at. That's what's fair. Dr. Vilk, what did he say? He was confronted on cross-exam. If Dr. Leckwood testified there was aspiration of blood into his lungs, would that affect your opinion at all? No, it would not. Even though aspiration can affect breathing? Again, look how it's worded. Even though it can affect. That it did. This is all theory. I've evaluated all the materials that Dr. Leckwood evaluated. And I agree, there may have been some aspiration because it showed up on a CAT scan, but certainly not enough to cause respiratory arrest or cardiac arrest. It was not seen on the chest x-ray. It wasn't seen in the tubes. It wasn't seen with suction. So there was a clinically insignificant, if any, aspiration. That's somebody who's the head of EMS, who's been an emergency care physician for years, who's a ventilation expert, who's written textbooks and chapters on this stuff. And it makes sense. And he's basing on the actual evidence. He's not hypothesizing. He's not trying to come up with a theory. That's what the evidence showed. And that's also in line with Dr. Budoff, the last witness you heard from, who said there's no fluid in the lungs because he didn't see on the x-ray. Now, Stanchik also testified the lungs were clear. So right here in the right-hand column, under comments, you wrote these words. Clear after ET tube, yes. What does that mean? Lungs are clear after the ET tube was placed. The patient man checked for lung sounds once he was in the ambulance and his lungs were clear, you could hear the air exchange in and out. So we've heard testimony about the aspiration. We've heard argument about the aspiration, but there was none to impact breathing. There was none. The myths, the black ink. And when confronted with that, what did Dr. Hugelin have to admit? Because he's the one who said it. Remember we started from a few minutes ago? He's the one who made that claim, that's what Leckwood said. I'm asking you about the airway, doctor. Are you testifying that Dr. Leckwood came in here and testified that when he got Kelly Thomas at UCI, after he'd been intubated by another hospital, that there was a significant amount of blood in his airway? Not the lungs, the airway? No, I misspoke. I think he really misspoke. He knew what he was saying. He didn't misspeak. He hoped nobody would catch that detail. He stated in his testimony that there was a significant amount of bleeding associated with the nasal fracture. So he didn't misspeak. Misspeak is, I said a word or two I didn't mean to say. I meant to say yes, I said no. Here, you know exactly what Leckwood testified to. So why didn't he say it the first time? Because the first time, he was trying to get one over on everybody. The first time, he was trying to convince you of something that wasn't true, and he got caught. So instead of saying what we all know really what happened is, I lied, I misspoke. How convenient. Now, yesterday the prosecutor also argued to you that it doesn't matter, he said these words, it doesn't matter if Kelly Thomas's heart stopped first or he stopped breathing first. It doesn't matter even if he had a heart attack. All that matters is he died at the hands of the police. That's all that matters. That's what he said in the beginning remarks of his opening statement, of his closing argument. All that matters is he died at the hands of the police. Now, there are implications in the statement, because he didn't die in the hands of the police, even at the hands of the police. But what he's saying basically is we have a video, and he ends up dying after a struggle. They must be guilty of a crime. That's it. That's all he's saying. So all the medical experts they called is admitted to that they were wrong. They don't support this case. They don't prove guilt beyond a reasonable doubt. They don't prove anything. It's striking, right? Because if his statement yesterday is taken seriously, what was three quarters of this trial about? What were we here? If his statement to be taken seriously, what about the causation that you have to find guilt? It's not there then. If his statement is taken seriously, what about the details and the facts and the law that you're supposed to apply in this case as jurors? He's saying ignore it. Black ink. So let's talk about what Mr. Markakis, Mr. Tanizaki, the prosecution want to ignore, the burden of proof. Now, these are not close to the law. These are just quotes from movies or books to illustrate a point, because all of us are lay people, and lawyers get used to using certain terms of art, and we're going to go through the actual instructions, but these are things that illustrate sometimes how people may think. We talked in voir dire about 12 Angry Men, how that movie depicted trial work or jury work. This is a quote from the movie. Juror number 2, beginning of their deliberations. You know, it's hard to put into words. I just think he's guilty. I thought it was obvious from the word go. Nobody proved otherwise. Now, Henry Fonda's character, juror number 8. Nobody has to prove otherwise. The burden of proof is on the prosecution. The defendant doesn't even have to open his mouth. That's in the Constitution. Now, that part may not be true about the Constitution part. It's a law we have in America. But that is the law. That's the burden of proof. The burden of proof is on the prosecution. The defense doesn't have to prove anything. And you walk into this case, and human nature is, wow, there's a video, and he was screaming, and he got, he's dead. So they must have done something wrong. Why would they be here? But on this one point, on the burden of proof, he's right. He's wrong. You have to look at the evidence. You have to look at all the facts. You have to see if the facts were proven to you beyond a reasonable doubt, and if there were enough of those facts proven to you to find guilt. That's what you have to look at. Now, you swore an oath to do that. And I say this because it's so important to all of us. Now, Mr. Akaka spoke about sending a message. That's wrong. You don't convict somebody to send a message. That's abhorrent. It's disgusting to our system. I'm not going to mince words. You convict somebody only and only if the prosecution has met its burden by proving to you that a crime took place beyond a reasonable doubt. That's it. That's what your job is. That's what our system is built on. That's what we depend on. That's what we teach our children. Not because I want to send a message. You don't do that. Another quote to look at. One of the things that we do worry about in cases of this nature. Two of them, actually. And being that is up on the technology, we like to use poster boards too. Human nature. People generally see what they look for and hear what they listen for. To give credit to a quote from To Kill a Mockingbird. Mr. Markakis, in his closing, all he sees is what he wants to see. And that's, most of the facts are left out of that equation. And all he seemed to have heard is what he wanted to hear. The problem with a burden of proof, the problem with being in this court of law, is you can't do that for the prosecution. Like it or not, you have to have the whole case, warts and all. And you can't cherry pick and ignore everything else. Because look at this instruction. If you can draw two or more reasonable conclusions from the circumstantial evidence, and one of those conclusions, reasonable conclusions, points to innocence, and another to guilt, you must accept the one that points to innocence. That means you can't cherry pick. Because there's another conclusion, another fact that shows innocence, that proves innocence, that demonstrates innocence, they're not guilty. That's what that means. And finally, this is why we have trials. This is why we have the prosecution having to put on evidence to prove a case. Again, To Kill a Mockingbird. If the real trial takes place in the secret courts of men's hearts, Is the public trial pointless? What purpose did it serve? That quote is talking to human nature and what that prosecutor is playing on. Ignore the evidence. Ignore the public trial, the court trial, where it's supposed to take place. Just pander, just sensationalize, just play to emotions. The secret court of men's hearts. That's wrong. That was worded, happened to be in the movie, out of a fear what could happen in the trial of an innocent man. As a defense attorney, in a case of this nature, we have the same fear. A fear that an innocent man, innocent men, won't be tried properly in a public trial where the rules of evidence apply, where the law applies, but in the secret trial of men's hearts. Emotion. One more quote before we start getting into the evidence. Actually, the law on presumption of innocence by Harry Truman. Something to think about, and it's really applicable to this case. And he said, way back when, intense feeling too often obscures the truth. That's a problem. We're all human beings. We have emotions. We have hearts. And Mr. Barnett said, and it's true, it's hard to listen to. It is. Now, for lawyers, it's a little bit less because we're looking at it and analyzing. We have a reason to listen to it. But it's difficult. But intense emotion obscures the truth. As a juror, as hard as it may be, to keep the foundation of this country safe from the government just deciding what should happen to people without any rule of law involved. I say government, I mean the prosecution. You're it. Mr. Barnett was right. You stand in between the prosecution and the accused. You're the check for that balance. That's who you are, which means the emotion is left aside for now. You're here to analyze. You're here to cross your arms and look at the prosecution and demand of them that before you argue to convict somebody, you better have proven it beyond a reasonable doubt. That's it. That's right there. That's the jury instruction that we've been reading for a few moments. Now, what is a burden of proof? We talk about presumption of innocence, burden of proof, reasonable doubt. We'll talk about more of the towards the end. But the reality of it is, we talked about this in voir dire, is in this courtroom, the only two people who legally are innocent, and we weren't there that night, so we could think that we're innocent of anything that's been charged. But the only two people who have a legal innocence in this entire case, in this room, are those two. That's it. And unless it's been proven to you with the law and the facts, beyond a reasonable doubt, they remain innocent. They were never guilty in the first place. That's what's fair. That keeps the government in check, the prosecution in check. It even keeps the public in check, because these kind of cases, they have a wealth of emotions to them. That's why we had all those questions of voir dire about media exposure and how much does the media expose you to, and were you influenced by the media? That presumption, doesn't work on that. The presumption, the burden of proof, that's what keeps all those other things in check. No, we don't convict people because of emotion. We don't convict people to send a message. The only time we ever convict someone is if it's been proven to us beyond a reasonable doubt. That's it. So now with some of that precursor, some of that foundation to talk about the charges, let's talk about them. Now, count 2 is involuntary manslaughter. My client's charged with. And for that count, we're going to put the jury instruction up. Replace it with the other one for a moment. Now, it says defendants are charged in count 2 with involuntary manslaughter in violation of Penal Code Section 192, paren B. What's important about this, really, is here. The elements. Committed a crime or a lawful act in an unlawful manner. 2, committed the crime or act with criminal negligence. And 3, it caused the death. You've got 2 parts to this that really have to be proven. Mr. Barnett went over some of this too. 1, we're going to start backwards in a way. 1 is causation. The acts have to they have to have caused the death. That means it's not by a coincidence, it's not by, well, it must have been that way, or it probably happened that way, or that must be what it was. They have to prove beyond reasonable doubt an actual causation, a nexus, a link. This was done, and this led to that. And here is the link. Here's the chain. You can see it. That's what they have to prove. But that's not it. First, they have to prove that a crime was committed, or a lawful act in an unlawful manner. And that wasn't proven. We'll get to that. But even if they passed that, then they have to prove it was done with criminal negligence. And that wasn't proven either, but we'll get to that. And here it says causation. Now, the instruction goes on to define a couple parts of this. The first one is criminal negligence. He acts in a reckless way that creates a high risk of death or great bodily injury. Reckless way. Reckless means he's not thinking straight. Reckless means he's doing something not just you wouldn't ordinarily do. Reckless means with no care, with abandon. Not somebody who's processing and assessing and adapting to the situation. Not somebody who says, okay, this didn't work, let me try this. That didn't work, let me try that. That didn't work, let me try that. That's not reckless. That's somebody who actually is processing information, who's thinking. And I think, and we'll go through it, but you've seen this trial, that's what my client did. He was thinking. He was constantly trying something when something else didn't work. He was reassessing constantly. Mr. Wilson testified to that. Someone's acting reckless. And a reasonable person would have known that acting in that way would create such a risk. Now, who's that reasonable person? A person who is in the same place as my client is. Similar experience, similar situation. Let me get to that here. In other words, a person acts of criminal negligence when the way he acts is so different from the way that he acts is so different. Not just different, so different. We're talking reckless. So different from the way an ordinarily careful person would act in the same situation, which means a police officer with his training, with his experience. Because none of us are in that situation. None of us are called out to 2, 3 code 3s. None of us have gone to arrive to see our partners fighting with somebody, not able to arrest them. A police officer in a similar situation. That his act amounts to disregard for human life or indifference to the consequence of the act. Now, as far as the crime for the first element, the prosecution alleges that my client committed a 149. The crime was assault or battery by a public officer. So they need to prove that to even get to this in reality. We're going to start backwards because this is the greater charge, but that's the reality of it. And they haven't proven that. And when we're done with this, it's going to be pretty apparent they haven't proven the 149 either. So let's put this one back up there. Because when we talk about proof beyond a reasonable doubt, we talk about how you should analyze the evidence and the law. This really is the instruction that tells you, because this is a circumstantial evidence case. And that's why the instruction's there. And regardless of the cavalier statement by Mr. Rakakis yesterday, that, most of the instructions don't apply. You spent an hour listening to them. They do apply. Now, some may apply much more than others. Some you may decide, depending on the facts, don't apply, but most of them don't apply. Most of them don't apply. Guess what? That one does. Causation. We're going to start with the second part of that first. And causation, right now we're here. An act or omission causes death if the death is a direct, natural, and probable consequence of the act or omission. Now, Mr. Burnett went over this, so I'm not going to belabor that per se. You heard about this. But here are the parts we're going to focus on. First of all, the act. Right? Second of all, a natural and probable consequence. That means it's foreseeable. The word's right there. That means a person, a reasonable person, with reasonable care, would foresee that this act would eventually lead to death. Would foresee it. So if it's not something you can foresee, they haven't proven causation. Not that it did happen. It has to be something that somebody would foresee would happen. Now, we're going to get to the point where it didn't even lead to death, my client's acts. But that has to be even foreseeable. A foreseeable consequence is one that a reasonable person would know is likely to happen if nothing unusual intervenes. So that's part of causation. It has to be something that's natural, probable, which means basically foreseeable. And the second part is it has to be a substantial factor. It has to be, that means they have to pick out an act, and they did, which is they're claiming excessive force. And that excessive force, that act, which again they've done, which the claim is my client's 2 strikes to the suspect's face. For them to be able just to pass this element, not the whole crime, just this element, that act, that excessive force allegation, has to have been a substantial factor in the cause of death. And we'll get to the whole myth of the compression theory, the myth of the blunt force facial trauma theory, that they haven't gotten it. It wasn't a factor at all. Because it has to be a substantial factor. Not that it happened at the same time everything else happened. This has to be part of the chain. And it wasn't. And moreover, it wouldn't be foreseeable. And that's just that element. That's the rest of it, which we're going to get into in a few minutes. Mr. Barnett also spoke about. If you have a reasonable doubt whether the defendant's act caused the death, you must which was the coroner's original, I say original, the cause of death that and she conducted the autopsy on Kelly Thomas. Her initial autopsy findings. This is the chronology, folks. This tells you how this case has been prosecuted from the start. She said that his heart size was bigger than normal. She said enlarged. Now, all that back and forth, Dr. Budoff and Dr. Karch, and enlarged and not enlarged, that's how she described it. She held it in her hand. That's part where the term of art comes from. Now, she's using the same term of art as a pathologist that Dr. Karch uses, meaning it weighs too much. And not just a little bit more, 20 to 25% higher than the highest part of the average. That's what she described. 480 grams. A normal heart size for Kelly Thomas would be 350 to 400. She said the lungs were filled with fluid, or had fluid in them, at the autopsy, and this is important. But she said, and this is her testimony, all the fluids came from being in the hospital, because he'd been on a respirator for a few days, and when somebody's respirated artificially, it tends to bring fluid in the lungs. And think about that. Because even Dr. Hugelin had to admit that since Kelly Thomas was basically being respirated artificially from really at the scene when he got the ambu bag put on with the oropharyngeal, through to St. Jude Hospital, through again now to UCI, he was having somebody do the respirations for him using that bag. Dr. Hugelin had to admit that itself would create some fluid in the lungs. That's why the CAT scan had fluid, because a little bit happens that way. I mean, it's just natural, because you got something over your face, and you're breathing it out, and there's some kind of saliva, there's some kind of, even a little bit of blood. It's going to go back down a little bit. Not enough to make any difference, because it's not on a chest X-ray. That's the actual evidence, folks. Because she also found no trauma to the lungs. No trauma. None. And after the gross autopsy, she had no findings. Now think about this. She claimed that the one piece of evidence, the one physical piece of evidence that in her mind led her to believe, along with the video, that it was compression was a bruise right here. That's what she claimed. She testified to that. A bruise right here. That's it. Not here, not here. One bruise here. Now, Dr. Hugelin talked about all the bruising on the body. That wasn't his partner's claim. Been doing this longer than him. One bruise right here. Right there. That was it. And think about this. She knew about that bruise after the autopsy, right? She found it. She watched the video once right after the autopsy. She testified to that. She knew that he basically died from not enough oxygen in his brain. She knew about that. And she knew about this compression theory also. All those things were at her disposal after the gross autopsy. And she had no cause of death. Nothing changed after that, but she had no cause of death. At the end of the gross autopsy, she knew all these things. But she said, at that point, she was still unsure how his brain was deprived of oxygen. So all the things that she claims now to have based her theory on, she knew then. So that she does a microscopic exam. She finds heart disease, but she feels not significant enough to be a cause of death. And Dr. Hugelin testified to that as well. She waits for the toxicology report. Negative results, no cause of death. So she's got no new information. She's got the bruise, she's got the video, she's got the theory, she's got the not enough oxygen in the brain. Nothing else new happens, but then she's visited by the DA's office to watch the video a second time. And lo and behold, same video, and this is interesting. Maybe it's because she heard Kelly Thomas saying, "I can't breathe." Maybe that changed her mind. But when she was questioned about that fact, about whether or not the second viewing, she had any audio on the video, and the first viewing, she said, "I don't remember." Not that, yes, I heard that, it was respiratory distress, and that's why I put 2 and 2 and 3 and 4 together. No. She said, "I don't remember I had the audio. I don't remember the first time I had audio. I don't know if the second time I had audio." So that didn't change anything. But the visit from the DA's office did. Now she has a cause of death. Nothing's changed except a visit by the prosecutor's office. Oh, for now, this seems, we can wrap this up with a bow. Mechanical compression of the chest. So somehow that can bring in Manny Ramos because at some point he's wrestling with him. Oh, and the facial injuries. That can bring in Corporal Cicinelli because he hit him twice in the face. Package it, put a bow on it, send it off for prosecution. What's the problem with that? She comes to the preliminary hearing where now she has to actually testify to it under oath at the prelim. And she says at the preliminary hearing, under oath, this is somebody who's used to testifying. It's her job. A compression was a discrete event. And she knows what that means. 1, this was under oath. This is a professional coming in a case like this with all the cameras and all the attention, testifying under oath. Here's my theory of cause of death. And one event, there was one compression. When it happened, he stopped breathing. That's it. So she testifies to. But she also says at the prelim that if he wasn't breathing, he couldn't yell or scream, because that's consistent with the theory. Once it happens, that's it. So all the yelling, all the screaming, he's still breathing. She said if he's talking, he's breathing. And you know what? So did paramedic Stanchik, so did Zilgit, so did Dr. Vilk, because it makes sense. And she said any talking he did had to have occurred before the chest compression. And she said the compression occurred at that very end, right? But at the very end, they're both off of him. But that's when she says it occurs. Because that's when the voice is waning out. According to their argument, that's when it must happen. But they're not even on him at that point. So there's a problem with this entire theory. It doesn't prove guilt. What are we going to do if we have to go to trial on this? We can break, Your Honor.
Take our new recess before we do adjourn now, ladies and gentlemen. I'll tell you we've done a little further investigation on this photographic issue, and as far as the thing is closed so far, we have one juror who is identifiable. We are attempting to find out who took the photos and appropriate action based on that. Also, because of this breach, I want to explain, these are not only my rules, these are rules of court. No jurors are ever supposed to be photographed under any circumstances. New policy, if we see a cell phone, it's confiscated. So if you want to keep your cell phones, keep them in your pockets or purses, because if one is out in someone's hands, it will be confiscated. It is your duty not to conduct research, disseminate information, or converse among yourselves or with anyone else on any subject connected with the trial, whether orally, in writing, or by any form of electronic or wireless communication. Not form or express any opinion about the case until it's finally submitted to you. Not have any contact with any of the participants. Will be in recess until 1:20 or 14. Should I see you in the hallway?
Understood.
Anybody else remain seated? Okay, the rest of you, oh, I'm sorry, forgot about number 14.
120, right, sir? 14? 120?
Okay, the rest of you guys are free to go.
Two's really
No,
shit.
Lingerie.